For years, Connecticut has had almost no oversight of homeschooling. A child could be withdrawn from public school and effectively disappear from any state record. In 2026, lawmakers changed that. House Bill 5468 became Public Act 2637. Its official title, an act concerning the provision of parent-managed learning. Governor Ned Lamont signed it on May 26, 2026. It didn't pass quietly. The public hearing alone ran almost 19 hours, with hundreds of parents, students, and advocates testifying. It ultimately passed the House 96-53 and the Senate 22-14. A real philosophical divide. So what does it actually do? At its core, three big changes, phased in over the next few years. First, starting with the 2027-28 school year, a parent withdrawing a child from public school to homeschool must appear in person to sign a withdrawal form. Mailing in paperwork or handling it entirely online will no longer be an option. A face-to-face step becomes mandatory. Second, also starting in 2027-28, before that withdrawal is finalized, the superintendent must check state child abuse and neglect registry records for every adult in the household, 18 or older. If any adult in that household is on the registry or under an active investigation by the Department of Children and Families, the withdrawal can be blocked. Third, starting with the 2028-29 school year, homeschooling parents must file an annual Intent to Educate form with their local district, due by October 1st each year. That form applies more broadly, too. By law, every family with a child aged 5 to 18 has to declare annually whether their child will attend public school, a non-public school, or receive what the law calls parent-managed learning. The state's Department of Education has to build these forms by July 1st, 2027, so districts have them ready in time. Earlier drafts of this bill went further, including portfolio reviews and standardized testing to prove a homeschooled child was keeping pace academically. According to groups tracking the bill closely, those portfolio and assessment requirements were removed before the final version passed. You'll still see some summaries online describing them, so it's worth checking the enacted text directly. Supporters argue this is long overdue. Connecticut currently has close to no homeschool oversight, and children withdrawn from school can simply vanish from public view. Groups like the Coalition for Responsible Home Education call this a critical first step, specifically pointing to Intent to Educate notification as basic accountability, not overreach. Opponents, including the Connecticut Homeschool Network, see it very differently. They argue the bill treats the simple act of withdrawing a child from public school as though it were evidence of suspected abuse. Critics also point out that the tragic cases sometimes cited to justify bills like this were failures of systems that already had oversight authority and didn't use it, not failures of homeschooling itself. There's also a legal fight underway. In July 2026, the Homeschool Legal Defense Association filed a federal complaint against the law. Their argument, automatically notifying the Department of Children and Families whenever a family withdraws a child to homeschool, violates a federal student privacy law called FERPA. Their position is that FERPA allows disclosing student records for educational purposes, not to trigger a child protection screening simply because a family chooses homeschooling. Because federal courts have ruled FERPA doesn't let individual families sue directly, that complaint goes to the U.S. Department of Education, not a courtroom. Since the law doesn't fully take effect until 2027 and 2028, no family has been directly affected by it yet. That's part of why this fight is still playing out mostly in testimony and regulatory complaints rather than in court. Connecticut isn't the only state dealing with this tension. Balancing child welfare concerns against parental rights to direct their own children's education is a debate playing out in legislatures nationwide. Whether Connecticut's version proves to be reasonable oversight or a step too far into family life is very much still being argued. Starting in 2027-2028, in-person withdrawal and a DCF registry check become mandatory. Starting in 2028-2029, an annual Intent to Educate form becomes required for homeschooling families, all under Public Act 2637. Where do you think the line should be between child welfare oversight and a parent's right to direct their child's education? Let us know what you think, and if you learned something new, hit like and subscribe for more breakdowns of the laws shaping Connecticut.